before we kick off. I'll just focus on just really briefly on some housekeeping. By way of introduction, my name is Jen Skeoch. I'm a partner in the employment law team here at Burness Paull, and I'm joined by my colleagues today, Fiona McClellan, who's a director in the team, and David Morgan, a fellow partner. We are your geek squad today, who are extremely excited about what we're going to be talking to you about the Employment Rights Bill. I'll come on to kind of give you a bit of an outline on the structure, but before we do that, just some housekeeping. You should be automatically muted when you join, but if not, if you could remain on mute, particularly because I know some of you are using this for your lunch hours, so we'll keep the crisp packet rustling to a minimum. You can pop some questions in using the chat function. I think today we're going to be quite tight on timing, so what we'll do is if there are any questions, we can collate them and we can get back to you separately. I should also say that although we're, as you know, always very happy to be as informative as we can on these sessions, if it relates to your specific organisation, it's really a question of how the new law is going to apply to you or any legal advice on that. We would need to take that offline and have a one-to-one conversation with you about that. And finally, today's webinar is being recorded, just so that you're aware of that. So thank you, Emma. You can take that screen off. So yeah, as I say, it's me, Fiona, and David today who will be covering really a bit of a reset and a summary of where we are at with the Employment Rights Bill. I will be giving you a bit of an overview from a sort of timing perspective of where we're at and what to expect in the next couple of years. I'll then be handing over to David, who is going to be talking on his pet topic of trade unions and industrial action, and a particular focus on the priorities for those areas of reform. Fiona will be covering discrimination law changes, and then it will be back to me on fire and rehire and day one rights. As you would imagine, we're not covering everything. This is really a bit of a headline sort of exercise, because we are, first of all, waiting for a lot of the details, but secondly, there are so many changes that have been announced that it just wouldn't be possible to cover all of them. So please do get in touch with your usual contacts if you've got any specific questions or topics that haven't been covered. But with all of that said, I'm going to kick off just really reflecting on the fact that the government have now published, on the 1st of July, they published a policy paper called Implementing the Employment Rights Bill, a roadmap, so described. And most of you will probably know that I'm quite cynical about the publications we get from the government, which are stated to be of assistance. But actually, this is quite a useful document, and I would encourage you all to have it as one of your favourites, or potentially sort of download it or print it out. We'll include it in the link to the written summary that we send round to this, but it gives at least some clarity on the phases of implementation and the next steps. So forgive me for actually reading a lot of this out, but I want to make sure that I get the detail of it right. So if we're taking it chronologically, over the summer, we've been told that we're going to have a consultation on the day one rights of unfair dismissal. So that's something that I know is a real concern for a lot of businesses and employers generally. That was the announcement that the qualifying service period is going to go, and there's going to be a right to bring an unfair dismissal claim from day one. So the consultation on that is imminent and should be out very soon, and I would encourage you all to participate in that if you have strong views on it either way. So that's the first thing that's going to land. Autumn 2025, further consultations on trade union measures and specifically simplification of the trade union recognition process. I'll leave it for David to talk more about that. There will also be consultation on dismissal and re-engagement, so-called fire and rehire. Again, that's one I'm going to cover in more detail later. Consultation on bereavement leave, increased rights for pregnant workers, and 0 hours contracts. The measures which will come into force first are those that will come into force when the bill gets royal assent. Royal assent has been sort of tentatively scheduled to take place at the sort of end of this year, autumn 2025. For reasons which I'll explain shortly, I think that might be pushed back a little bit because it's got to go through all of the final stages of the parliamentary process. But once that happens and the bill becomes an act, the things that will change immediately are there will be a repeal of most of the Trade Union Act 2016. There will be protection against dismissal for taking industrial action and a simplification of industrial action notices and industrial action ballot notices. So again, this is David's bag and he'll mention those in his session shortly. Winter 2025 and early 2026, more consultations on further trade union measures, collective redundancies and flexible working. Then April 2026, which I think is really where the changes begin to bite in terms of things coming into force. So due to come into force then are the increase in the maximum period of collective redundancy protective award, whistleblowing protections, which are still TBC, removal of the lower earnings limit and waiting period for statutory sick pay. Crucially, the simplification of the trade union recognition process and electronic and workplace balloting will be due to come into force in April 2026. Then October 2026, so you can see the sort of staging typically works in two tranches throughout the year, April the 6th and then the 1st of October. So the October 2026 changes will include the fire and rehire changes, the all reasonable steps to prevent sexual harassment change, and the third party harassment provisions coming in then. There will also be an extension to the time limit for tribunal claims up to 6 months at that point. The duty to inform workers of the right to join a trade union and the access rights for trade unions will be October 2026 as well. And then 2027, and we've not been told whether it will be April or October in 2027, but coming into force then are the day one rights. So day one rights protection from unfair dismissal, equality action plans being required. There will be introduction of a power for regulations to be made specifying what steps are to be regarded as reasonable to determine the all reasonable steps to prevent sexual harassment, which is rather frustrating that they're bringing in the law and then bringing in the explanation of how you comply with it later. A new collective redundancy threshold in 2027 and day one rights to bereavement leave in 2027. So that's a really quick run through and we can share that with you as part of the follow-up. But I think that's helpful for you. The reason I think it's helpful is if, as we expect you're doing at the moment, you're sitting in terms of working out your priorities and what changes are going to come around the corner first and what you really need to prepare for as a matter of priority, you can use that chronology as a bit of a guide. The roadmap does make it clear that there are going to be various sort of offshoots for each of these. So you've got consultations that will be running and then it's, you know, a question of what comes out from that consultation. Will that make any difference to what's being proposed? There will also inevitably be some codes of practice, statutory codes of practice that are either revised or completely sort of created as a result of some of these changes. There might also be secondary legislation, so regulations that come into force to give effect to what's coming in the Employment Rights Bill. So although the bill itself is the sort of the platform for everything, be aware that, you know, we're a long way before we actually have clarity and detail on exactly how this will all work. And before handing over to David, I just wanted to mention where the bill actually is sitting as part of the parliamentary process. So it is at an advanced stage, which is why people are talking about royal assent in autumn 2025. But it's at a really interesting stage in that it's at its report stage in the House of Lords. So there was a second sitting of the House of Lords report stage on the 16th of July, at which there was discussion of some amendments to the bill that had been tabled earlier on this month. And it's hard to keep track. I don't envy you trying to keep track of where we're at on certain things. But I will come on to explain later some really significant amendments that have been proposed to the fire and rehire proposals. And the Lords at the second sitting on the 16th of July approved all of those amendments. So I'll come on to explain what that means, but that is a watering down in effect of the fire and rehire proposals. And what I wanted to flag to you just now was that, interestingly, at this second sitting, the following other amendments, which were not government amendments, were also agreed by the House of Lords. So they have effectively said that instead of a day one protection for unfair dismissal, they would go back to the sort of earlier model of a 6-month qualifying period. So just take it from 2 years down to 6 months and get rid of the proposal for day one rights and the sort of statutory probationary period. I'll come on to talk about whether it's likely that that will go through and what that would mean. But there were various other things that were discussed at the House of Lords, as I say, on the 16th of July. And what now happens is it goes back to the House of Commons, and you might have heard of this sort of concept of the sort of ping pong between the House of Lords and the House of Commons. And I think the difficulty is that, Labour from a manifesto perspective will be very keen on ensuring that all of the headlines that they had promised and all of the things that they've put in the Employment Rights Bill do get through, but we're already seeing quite a lot of resistance at the House of Lords stage. So there's going to be a really interesting period, I would say, over the next week. Then there'll be summer recess, and then when Parliament comes back after summer recess, there will be more of that ping pong until we get to a sort of reduced stage where we know finally where we land. But that's where we are at the moment in terms of the parliamentary process. And with that context, I will hand over to David on what we think is one of the biggest priorities for all of you at the moment.
Excellent. Thank you very much, Jen, for that introduction. And as we'll kick off on the trade union side, I'm still kept very busy, as Jen alluded to, on the trade union dispute side, both in terms of pay bargaining disputes we're seeing clients faced with, and also preemptive work supporting employers who are faced with recognition campaigns and applications for recognition by trade unions. So I'll spend the next 3 hours discussing, no, I'm only joking, don't worry, despite being my pet subject. So the next kind of 10, 15 minutes, we'll touch on these trade union developments. And when looking at not only has the roadmap kind of refreshed where we have a bit of insight to the timescales for this, there have been some proposed developments to the legislation along the way. And actually, some of it is watering down some of the original fears that we had, if you like, in terms of what the legislation might do for employers. But suffice it to say, you might expect the Labour government, despite maybe falling out of favour with Unite as one of our largest or the largest trade union in the UK, they're still very much, as you'd expect, beholden to the trade union movement. And really a lot of this stated aim is to make things easier for the trade unions. One, to call upon their members for industrial action, and second of all, to get a foothold within businesses, within employers for trade union recognition. So in this Law Lab, that's the two key topics I want to touch upon: where we are, what the direction of travel is, and a bit of a recap on what the proposed changes are around, firstly, industrial action, and secondly, the law as it relates to statutory trade union recognition. So first off, on the key amendments on the law as it relates to industrial action, some tinkering, some a bit more significant. The first, as Jen mentioned, was around the ballot notice period. So whereas now employers are given, and forgive me the term, but this bomb warning, if you like, of 14 days when you know on a notice of industrial action that there will be industrial action in the business within 14 days. That was proposed to be cut to 7 days. It's now looking at 10 days. So a slight change change there as the legislation has worked its way through consultation. Similarly, there's what we have as a mandate for strike action. So this ballot, if approved on a vote, will be live currently for a period of 6 months, before which the union has to go back to its membership to get another mandate. The proposal is to increase that to 12 months to avoid the need for frequent reballoting. Autumn of 2025, when the legislation receives royal assent, is when that's looked at coming into force, as Jen said. So some of the trade union measures are easier to implement than others. And I think that's where the thinking and the commentary around this is. Some of them come in quite quickly because they're amendments to existing law that's already on the books. So if the government can just implement a change, it can be processed more quickly than if it was an altogether brand new piece of legislation, like some of the examples Fiona and Jen will cover. Again, moves are afoot for e-balloting for strike ballots. Currently now they must be done in post, and that's been something that the union movement have pushed for a long period of time, to have e-balloting introduced as the preferred method to garner votes. That's not until April of 2026 that they're looking at that, so still very much subject to consultation. Another high profile one here will be the ballot thresholds. And a lot of this really is simply the unraveling of the original or the more recent Trade Union Act of 2016, which the Tories led on. All of that's being unraveled. And probably one of the key headlines from that legislation was this 50% threshold. So there must be a minimum of 50% turnout before a ballot for industrial action can even get off the ground. That will be repealed. Again, that's an early one for autumn 2025, and it'll be replaced just going back to the previous paradigm, which was a simple majority. So again, very much designed to help the trade unions get the numbers much more easily. Similarly, quite an early tearing up of previous legislation from the Tory administration. Won't affect all of you on the call, but the repeal of what we had as the Strikes Minimum Service Levels Act. So this is where you had to have a minimum level of cover for workers in important areas such as health, transport, education. So again, that is being repealed such that those minimum levels will now disappear. There's other additional protections that are being introduced or proposed for the law of industrial action. Importantly, making the protection from detriment and from dismissal protected all the way through. There's currently a 12-week protected period when workers have protection. That will be lifted such that there'll be protection all the way through, and the right, therefore, to claim unfair dismissal on the back of that. So again, much more around individual trade union rights flowing from the trade union movement. This has been a bit of a flip-flop, the legislation on agency workers, and it will be clearly stated, going back to the original position that we were used to, which is there's a ban on using agency workers to break strikes. So again, that will be set out very clearly that is the case. And the final one I'll mention, that's nothing in writing yet, but there's commentary around. Currently, one area of strike or industrial action that's banned is what we call sympathy or secondary industrial action, which is effectively where, let's say, there's a trade dispute in employer A, and employer B is faced with strike action from the trade union to call out in sympathy with employer A. So it might be customer or supplier type arrangements. That's currently unlawful. It's unlawful to have secondary, as it's called, industrial action. It must be industrial action to be lawful, must relate to the trade dispute, as it's called, must relate to the particular employer and that employer only. And there's talk and consultation around that being permitted. And again, be quite important for those of you with supply relationships, customer relationships, where people are coming out effectively in solidarity for their union colleagues in a different employer. So we'll be monitoring that one as well. The next one that I want to cover, and I think this is very important for us from a preemptive point of view, and this is something I think all employers should be considering now, and it's around the changes to the law as it relates to statutory trade union recognition. So the kind of headline, if you like, from the Labour government is that they view that the current hurdles and the current process that's in place to enable a trade union to approach an employer from compulsory recognition is too difficult. It makes it too difficult to gain trade union recognition. Now, statistically, if I can give you an idea of the kind of scale of this, the adjudicating body for this, the body that you go to, is called the Central Arbitration Committee, or the CAC. It's almost an employment tribunal in steroids, I sometimes describe it as. So very senior Labour professors will sit on that together with a panel from industry and also from the trade union movement. And they just published their annual statistics, and I think last year there was something like 65 such applications that were proceeded throughout the UK. So not huge numbers, but we do foresee more on the back of that. The averages are around that across the UK. A lot of these cases will then end with a voluntary agreement, but some of them will be involved in supporting clients in resisting trade union recognition being imposed. So a couple of headline grabbing points that they're looking at doing. The first is to have more of a presumption in favor of automatic recognition. So if the union has a majority of membership, if they can establish a majority of membership that is over a simple 50% in their proposed bargaining unit, the law already states that can be imposed. However, there's an option for the employer to look for a ballot if it's in the interest of good industrial relations. What the government's proposing to relax there is that it will only be in very exceptional circumstances that there would ever be a ballot. And it's only if there's a good reason to doubt the figures. So I think that's again much more about, look, if you've got 50% in the bargaining unit, you're likely to have that imposed upon you. So that's one of the first streamlined changes they're looking at. When I presented on a law lab on this topic before, one of the concerns again was about the reducing of the thresholds. As the law currently stands, for an application for recognition to get off the ground, there must be at least 10% of membership in the proposed bargaining unit. And you need to, the harder part is to establish there's at least, there's likely to be a majority of support in that bargaining unit. And usually that's on petitions and it's a relatively low bar of proof there. And a lot of the commentary and the headlines were around that being reduced to 2%. From 10%, and that's been removed as the bill currently proceeds. And instead, they're going to stick with the 2%, but give the Secretary of State the power to reduce the 10% in future. Okay, so I should say, however, 10% is a pretty low bar. I've got one case on my desk just now where the bargaining unit is only 60 people, so that's 6 people. So it's not a huge bar in any event, but certainly 2% would have been a very narrow threshold. And the thinking behind this is I'm going to come on to talk about, I think Jen touched on access rights. So that's probably the big thing I want to focus on as a takeaway for you, which is the union having access to the workforce as part of the trade union recognition process. The thinking is that that will make it much easier for employers to gain membership and to recruit. So that's the thinking behind not reducing the 10% down to 2%. So I'll come back to the important issue of access rights. The other thing is ultimately, if there's not 50% of membership in the bargaining unit to give you automatic recognition, these cases turn, as I often put it, on a numbers game, and it will come down to a vote. And they can become quite heated and quite contentious campaigns and votes ultimately, where broadly speaking, as we currently have the law, there's a 40% threshold where 40% of the entire bargaining unit must vote yes to recognition, and a majority of the actual voters must support recognition. It's a double test. The previous and the original proposal was that that would be amended and that the 40% would go and it would just be a simple, general election style vote of a majority in favor of recognition. The proposal is to remove that as things stand, to take away that change. In other words, it will stay as the law as we currently understand it with the 40% plus a majority. So that's where we are. But the government is saying that they will review the thresholds to ensure democratic legitimacy while removing unnecessary barriers. So again, they've kind of reined back a little bit from that they'll leave it at the 40%, but they'll keep things under review. So that's currently where we see the law as it stands. A next one, which I think I certainly took a lot of interest in because it tends to be the tactic that we often employ when acting for employers, which is around the bargaining unit. And what the government has spotted is that tactic, which is that often employers will use tactics to dilute the union membership by broadening the bargaining unit. So it very much, as I mentioned, is a numbers game. So increasingly, or usually, the practice for the union movement is to target one site or one location, maybe where they have their membership for recognition. And let's say it's in a multi-site business where you have, say, retail operations, you've got 10 sites, they go for one site only where they have the membership. Invariably, what the employer would say is, well, that's not what we call compatible with effective management. That's the test as it currently stands. So you say we should widen the bargaining unit to cover all 10 locations. And lo and behold, that will inevitably dilute union membership. And sometimes those cases then wither on the vine. So the government is saying we've spotted this, and they will look at a more worker-focused definition, putting much more of an emphasis on the proposed bargaining unit, less emphasis, frankly, on what the employer says or wants, unless there's a strong reason to do otherwise. So I've not seen in black and white what the law will be in this yet in terms of how they would change the current criteria. And the current criteria includes the views of the employer. It looks at the commonality of terms and conditions. It looks at the location of the workers, the type of job categories in scope, and a desirability of avoiding small fragmented bargaining units. The test under a more worker-centric model would be more focused on common working conditions, community of interest, existing workplace structures, and importantly, not just the employer preference. So again, it'll be interesting to see how, because that will be quite a shift from how we've seen the CAC applying the existing law operate in practice. So again, more steps designed to help the trade unions get their applications over the line. So we're very much watching the space on that as well. And finally, as I mentioned, an important, a big development is union access. So this is about creating a framework when a trade union wants to get recognition, to get their foothold in a business. So this is where you don't currently have recognition. So for those of you in the meeting that do not currently recognize a trade union, if you're faced with a recognition application, right from the outset of that, as soon as the application is made to the CAC, there becomes a 20 working day window during which you must agree with the trade union access to the workforce. Okay, and that means a sales plug effectively, the opportunity for the trade union to come in and to present to your workers and sell the dream of unionization and union membership and recruit members accordingly. As the current law stands, there's only scope to do that in the lead up to the ballot, when the union gets the opportunity, often just one meeting it will be, to come and present to say, please vote yes for recognition. So this will be a huge difference for those of you that do not currently recognize trade unions. It's quite a modern approach to this because it covers not just in-person on-site meetings, perhaps some rest breaks or even during the working day, but also internal digital systems, access to things like Teams, Slack, intranets of the company. So you've got to come up with a model for this, an agreement. There's no model agreements out there. We'll probably be drafting these freestyle when we get used to the new law. And there's old school measures such as the old notice board, a union site. For those of you that have unions already, there'll be a little area on the notice board. So you need to agree that. If you don't agree that, the CAC can either impose it upon you or it could even go so far as to impose recognition automatically for your failure. So quite an onerous step here, being the penalties. But more importantly, I think for me, it's the action that this involves in terms of your workforce but being exposed, as I say, to the union movement coming to sell the benefits of recognition. So all of these changes as it relate to union recognition are probably the biggest change we've seen since the law came into force in 2000. But it's a much lower bar now for entry, it will feel, in terms of the ability to gain recognition. And the dates for this are either some of them April or October 2026. Okay. So if we take April 26th, it's not that far off. And I guess the key takeaway I want to leave you all with, for those of you that do not have trade unions in your business, we are strongly encouraging and indeed working with many clients to assess and audit the current workforce that you have. Look at what your communication and engagement protocols are already. Do you have in place already consultative committees, employee forum, etc.? What is your approach to employee voice, employee engagement? What would you say if a trade union were to approach you in terms of how you engage with your people? You might want to look at certain sites, as I mentioned, because the way to recruit usually by trade unions is to start local and then broaden. So look at certain sites, auditing. If you have a feel you don't ask people their union affiliation, you should respect their right to be members. It's not about victimizing, but more just getting a sense of where membership pockets may be. And probably a key takeaway will be training. Increasingly we are offering training sessions directly to managers, training managers on how to have a conversation about unionization, what the company's stance is on unionization, what it means, what the law says, how you would deal with it. Because in practice, without that, invariably these are tricky conversations and things that I find managers just don't talk about. They don't know what to say, so they say nothing. And that really is the opposite of what we'd be encouraging. So that communication approach is vital. And in these difficult times, or times when a union's targeting a business, we talk about over communicating with the workforce so that they know what this all means. And that includes driving that from the management population as well. So, in conclusion, really, Jen, it is that takeaway for me that this is a window of opportunity before the law becomes good, that employers can take steps now to engage and to be ready for this before the process moves remarkably quickly.
Thanks, David. And I promise I am not just saying this because he is my fellow partner, but there is no one that is more of an expert in this area than David. I can attest to that because I sit next to him most days and I hear him talking about this day in, day out. But I would urge all of you who maybe have that instinctive feeling of, I've not had to deal with union stuff for years, or I would really need to dust down my notes on that, I would highly recommend investing in some training, particularly some of David's kind of refresher courses on the fundamentals. I know that's been really, really useful to a lot of our clients to start feeling prepared for conversations that they maybe thought they just wouldn't need to have in their workforces. And as I say, the trade union changes are really priority number one in terms of the sort of chronology. So thank you very much, David. And I will now hand over to Fiona, who is covering off discrimination in the broad sense and some specific changes.
Yeah, thanks, Jen, and thanks, David. So I am going to focus on kind of key updates from a diversity, equality, and inclusion perspective. And Jen has already touched on timelines, so I'm just going to quickly highlight the roadmap updates in terms of anticipated dates from a DE and I perspective, just so you kind of know what's on your radar for people who focus on that. So still quite a while to wait. April 2026, there's a planned introductions of day one paternity leave and unpaid parental leave. And then it's not until October 2026 that we anticipate then there'll be the amendments which will require employers to take all reasonable steps to prevent sexual harassment of their employees, and also the introduction of an obligation on employers not to permit harassment of their employees by third parties. And then we've got a 2-year wait. It's not till 2027 where we're expecting the mandatory gender pay gap and menopause action plans to be introduced, and also the increased rights for pregnant workers and expected changes to both flexible working and bereavement leave. So that's just to kind of have on your radar, because I know you'll be thinking about updating policies and wanting to put everything in place and be proactive rather than reactive with all the changes that will be happening. However, the key DE and I update today to discuss is that there has been an amendment to the Employment Right Bill regarding non-disclosure agreements. So these are commonly referred to as NDAs in the press. And you probably actually heard about this because I think it was reported in the mainstream media and BBC News, etc., that there has been an amendment, and this is a government-backed amendment, which means it is likely to go ahead. So what I plan to do is I'm just going to read you the new clause that has been inserted into the Employment Rights Bill, and then just chat through in a bit more detail the rationale for this and what this means going forward and what you need to be thinking. So the bill has been amended, and there's a new provision which is titled Contractual Duties of Confidentiality Relating to Harassment and Discrimination. And what it says is that any provision in an agreement between an employer and a worker of the employer, whether a worker is contract or not, is void insofar as it purports to preclude the worker from making an allegation of or a disclosure of information relating to relevant harassment or discrimination, or an allegation or a disclosure of information relating to the response of an employer of the worker to relevant harassment or discrimination, or the making of an allegation or disclosure within paragraph A. So this would be a fundamental change to the enforceability of confidentiality clauses in employment agreements, and that includes settlement agreements where they are, or historically certainly have been commonly used. And then the amend, if it comes into force, would mean that any provision in an agreement between an employer and a worker is void if it precludes the worker from making allegations or disclosure about harassment or discrimination. And the amendment also covers disclosures about an employer's response to allegations of harassment or discrimination. So this would apply to settlement agreements, contracts of employment, and any other agreement between an employer and a worker of the employer. Interestingly, and this has been highlighted in quite a lot of the commentary about it, that as currently drafted, it only covers discrimination and harassment, but it doesn't apply to failure to make reasonable adjustments or victimisation. What I would say in victimisation is it does cover the response of the employer to an allegation or disclosure. So it would seem a confidentiality provision could potentially cover victimisation in some scenarios, but it's not 100% clear. And the other thing I would say is I suspect that the scope may broaden in due course anyway. So it is a case of watch this space. But I mean, I don't know if it's just a kind of an error that they missed out failure to make reasonable adjustments situations, because I think that probably is one of the most common types of cases we see coming through in terms of tribunal claims. So I think it's just about watch the space in terms of whether it will broaden the scope to also include those claims in victimisation. So why have the government decided to do this, and what have the government said about the rationale for this amendment? So what the government said in their press release was that the Employment Rights Bill will ban employers from using non-disclosure agreements that silence workplace harassment and abuse. And then the Deputy Prime Minister, Angela Rayner, she's also been quoted saying that we have heard the calls from victims of harassment and discrimination to end the misuse of NDAs. It's time we stamp this practice out, and this government is taking action to make that happen. The Employment Rights Bill will ban any NDA used for this purpose so that no one is forced to suffer in silence. And I think, everyone in the call, I'm sure, will all agree that the aim of the provision clearly has merit, and the intent is to protect employees that suffer from workplace discrimination or harassment. And we've also seen, and I'm sure again, probably all of you have been aware and discussed internally, that NDAs in the workplace have become a really prominent topic in recent years, and the routine use of them in settlement agreements has faced a lot of criticism. We've seen the rise of the Me Too movement and the increased willingness of victims to come forward and speak up, and I'm sure we all agree that that's a positive thing. There's been a number of high-profile cases. There was obviously the Harvey Weinstein scandal. There was also the McDonald's expose that uncovered a toxic culture where sexual harassment seemed to be commonplace. More recently, there was the conduct of Mohammed Al-Fayed, and that's had significant press attention too. And in all these cases, there has been people signing NDAs, and the use of NDAs seem to have occurred, and that has been heavily criticised. And they are situations where people were trying, effectively were silenced after suffering from harassment and or discrimination. And over the recent years, with these type of high profile cases coming up, without doubt, there has already been a change from employers. Previously, I think there was an expectation. Employers often thought that when signing a settlement agreement, there would be a belts and braces confidentiality provision that would just be included as normal. Whereas now we would say that employers should be considering on a case-by-case basis whether confidentiality provision is actually needed. And it shouldn't just be viewed as a given, and it shouldn't automatically be included in standard template documents. So I think there already has been that shift from just it automatically being in there. Now, if it is in there, it should be considered. It should be a case-by-case basis if it's appropriate, and you'd also have a number of carve-outs that would be expected to be included too, which you'll commonly see in settlement agreements. And the Equality and Human Rights Commission, they've issued guidance on best practice, and also for solicitors, the Solicitor Regulatory Authority, they have also previously issued a warning notice regarding the use of NDAs, and we're always very mindful of how they're used. So there's already been a shift, and I think that's been seen, and I think it's not just an area of employment law and HRER that we're all living in, but I think you'll also see, like in the mainstream news, there's been quite a lot of reports on how they've been used in recent years as well. So it has been a hot topic of conversation, and it's probably, it's not I suppose it's not unexpected maybe that the Labour government have wanted to make a change in relation to this. But no doubt this new amendment, the new provision, would go even further than what the changes we've seen in recent years by banning them, or if they are included, making them void in regard to discrimination and harassment. So it would certainly be a step further than where we are already in terms of the landscape. Now, a consequence of this does become law is that it may be that employers will be less inclined to agree exit packages under settlement agreements with employees if they are, not going to have these confidentiality provisions included, or if they are agreeing to settlement agreements, then they may only be willing to pay smaller settlement sums. It also may lead to more discrimination and harassment cases running to final hearings at tribunal, which I'm not quite sure how the employment tribunals will survive with that, because I just feel that they're going to have more and more cases with all these changes, and they already seem to be struggling in terms of tribunal dates, because we're seeing many tribunals be listed in 2027 at the moment. So, I mean, I think we all agree, the aim and the intent behind it is obviously has merit, and we don't want people to be suffering in silence at all. I think one thing to think about is that some employees actually, they may prefer to agree a settlement package rather than being involved in a long-running litigation, and they may also prefer for both parties to mutually agree to keep matters private, and each case will be fact sensitive and depend on individuals. So I wouldn't be surprised if the final version of the provision might include some exceptions to the rule, where an employee can potentially proactively, in this, I mean the employee doing this, not the employer, that the employee might actively ask for a mutual confidentiality clause to be included with appropriate carve-outs. One of the reasons I wouldn't be too surprised if we see that is that I'm aware that last year in Ireland, the law was changed there to provide for a restriction in the use of NDAs, and that was similar, like in respect of discrimination, harassment, sexual harassment. I think that also included victimisation, but there are some exceptions that apply. So in Ireland, NDAs may be entered into as part of terms of settlement agreement under specific situations, and one of them is that if the employee requests for it to be included, and that the employer agrees to pay for independent legal advice for a reasonable sum. So it would be, I still think that if there was an exception, it'd be that the employee would be requesting it, but I wouldn't be surprised if maybe that's included, because as I said, some employees may prefer that there is a mutual confidentiality clause in certain situations. So we'll just need to wait to see if the UK legislation is later updated to include that type of carve out, but I think it's just a really case of watch this space. I do think because it's government backed, this will likely go ahead in some form. The wording might be slightly tweaked. In terms of timing, when it might go ahead, we don't know, because the new provision wasn't on the roadmap. We don't know when this will come into force, but obviously we'll keep you updated and let you know as soon as we hear any more, which we'll do in terms of all the updates. But for now, that's where we are. Any follow-up questions you have on it, you are happy to pick them up direct with you. But I'm sure it's probably not completely unexpected, but they're just keeping on our toes with our amendments anyway. But I'll hand you back to Jane now, who I think is going to go on to fire and hire.
Yes, thank you. Thanks very much, Fiona. As you say, not entirely unexpected, but I think quite a lot of the detail needs to be worked through on that. So the last two things that I want to cover are fire and rehire, and then day one rights really briefly. On fire and rehire, there had been in the Employment Rights Bill some pretty bold changes proposed, which would effectively make it, I think, in a nutshell, impossible for employers to use dismissal and re-engagement for changing terms and conditions of employment, except if the business was about to go bust. That was in a sort of loose sense what the provisions of the Employment Rights Bill said, that those dismissals would be automatically unfair unless there was like a kind of business critical situation and it was like a last resort. Now, just sort of, I guess, zooming back from the Employment Rights Bill a little bit, dismissal and re-engagement, or fire and rehire, as the government has now sort of changed the terminology to, dismissal and re-engagement has always been a lawful, potentially lawful tool that an employer can use when it's considering making changes to terms and conditions of employment. I could do a whole session on how to go about making changes to terms and conditions of employment, but those of you that have done that will know your first step is always looking at the contracts that you have in place, whether they're in writing or whether they're in custom and practice, and working out if the change that you want to make is already permitted under the contract. If it is, then you don't need to worry about these sort of mechanisms such as dismissal and re-engagement. If it's not permitted under the contract, you're then hopefully looking at consulting with employees and getting consent to the change and documenting that by way of a variation letter, and that's all good. Where things get really difficult and really complicated from a legal perspective is where you can't already use the existing provisions of the contract to make the change, and you have employees who don't agree. And your two options there, if you are determined to make the changes, are unilateral imposition of the change. So just notifying employees with effect from this date, we are making the change. We've heard what you've got to say, but we are going ahead with it. Or alternatively, giving notice of termination of employment and offering them immediate re-employment on the revised terms. So it sounds really draconian, the dismissal and re-engagement option, but it is potentially lawful. The way that you would defend those claims, if someone raised an unfair dismissal claim because of the termination, you would defend it on the basis of it being potentially fair as some other substantial reason. And you would have to go through your business rationale for it, the consultation that you'd gone through, and why that was considered a reasonable thing for you to do. So this is not a new concept, and as I say, it's something that employers have had in their toolkit for a while. I think employers use it reluctantly because they really don't want employees hearing that message of, we are going to terminate your contract and offer you engagement on revised terms. But it is permissible under the current regime. The government have had dismissal and re-engagement in their sights for some time. There was the big P&O scandal a couple of years ago, and that, I think, really crystallised the issue. And so there have been various consultations and kind of public statements made from the government on the basis that they're going to ban and outlaw this practice. And I mean, I feel quite strongly that in some ways it's been sensationalised, and actually there's not an appreciation of the fact that from a contract law point of view, this is a recognisable mechanism, and that employers have been doing it for a number of years, and it's open to challenge in the employment tribunals already. However, we are where we are, and the government has said it's banning them. So that's what the Employment Rights Bill was trying to achieve, as I say, with this very minor carve out for business critical situations. There was a lot of pushback and a lot of lobbying by businesses to say, look, this is really going to hamstring businesses in circumstances where they have to make changes. And maybe the business isn't in a sort of critical situation, but they are really sound, or they have sound business rationale for it. So the amendment that has been proposed by the government, and so should certainly go through and has been approved by the House of Lords, is to water this down so that only restricted changes to terms and conditions of employment will result in an automatically unfair dismissal if the mechanism used to make that change is termination and re-engagement. More work, I think, for all of you to understand, well, okay, is this a restricted change or is this not a restricted change? They've given a list at the moment, and effectively we're talking about things like pay, hours and holidays, which you would predict. So any changes that fall into the restricted change category will still have the result of producing an automatically unfair dismissal. So you're not going to be able to make those changes and push them through using dismissal and re-engagement, even with this amendment. They've also made a slight change to make it clear that even if you hire workers or casual workers rather than employees, you will be caught by the regime. So they're saying you can't use this device to terminate employees who are on, expensive contracts of employment and then rehire agency workers or workers rather than employees on less favourable terms. So they're effectively, I think, filling the gaps of some holes that had maybe been spotted in the regime in the earlier drafts. So there's going to be a consultation on this, as I mentioned at the start, in autumn, and we'll see some more detail on how this sort of restricted variation test will work. I would encourage you all to think about the applicability of these changes to your business, though. We're seeing a lot of employers, and it's just the market that people are operating in at the moment is very challenging, and there are actually a number of changes to terms and conditions that are being considered more so from a place of employers wanting to ensure the business is sustainable and to avoid redundancies. So actually coming at it from a sustainability point of view. And I would urge all of you to sort of prioritise looking at your contractual position at the moment and having a think about whether some of the things that you may have thought about maybe putting off for a couple of years down the line, do you need to tackle those issues now before this change comes in, which will significantly reduce your ability to make any changes. And if you need any help with that, then please do let us know. And then finally, as I mentioned before, the big headline in all of the Employment Rights Bill had always been day one protection, so the right to bring an unfair dismissal claim on day one, and that had been a manifesto promise from the Labour government, and it tracked through the whole way of the Employment Rights Bill. Interestingly, now that is like the last thing that's coming in. So we're talking 2027, and I expect it's going to be October 2027. And the reason for that, I think, is that the government has heard the kind of cry from businesses to say this is going to be massive. I think it's estimated that will unlock potential claims for about 9 million workers, which actually is quite a sobering thought when any of you who are currently experiencing employment tribunal claims are probably already feeling frustrated with the fact that the tribunal system is kind of on its knees, particularly in England and Wales. It's taking a very long time for cases to really go anywhere. And so if you add in another 9 million potential claimants, I think that's going to be highly problematic for the system to deal with, never mind the employer to deal with. So as I said at the start, the House of Lords have got a role to play in shaping the ultimate output of this legislation. And there was a proposal from, it was a Conservative peer, but basically saying, look, we get it, 2 years is too long. People need to have protection sooner than that. But this whole day one rights with a statutory probationary period and a different test applying to unfair dismissal claims for that first 9 months is just too complicated. let's just go back to a 6-month continuous service requirement. And that's been approved by the House of Lords. Now, that doesn't mean it's happening, but it's quite, I would say it's quite noteworthy that the House of Lords, which obviously has a mixture of Conservative, Labour, Lib Dem, Green, there has been a majority of them that have said, yeah, that makes sense. So ultimately, I don't think the government will bend on this. As I say, it was one of their manifesto pledges, and I think they will feel, that they can't compromise on this. But that has been now punted to the House of Commons for consideration and debate. So it's an interesting development. We will let you know as soon as there's any clarity on this. And then the next step for you to kind of be aware of is a consultation on the Day 1 rights. And as I say, if you are interested in submitting any feedback on that and shaping the process, you should do so. And then it will be 2027 before it comes in. So you do have a bit of time to prepare. So we are at time. Thank you so much for joining us. We'll circulate a link to the recording of this and summarise it for you as well. And as I say, please do reach out to any of your contacts if you've got any questions at all. So thank you all so much for joining, and we will see you very soon, I'm sure.